Okay. Hey, welcome back to the Peace Officer Standard Accountability Division's Q&A session. I believe the intro was not heard, so I'll go ahead and just briefly cover this. The goal of this session is to answer any questions you may have about Senate Bill 2, the 9 areas of serious misconduct, notifications by post, and anything to do with the decertification process. I'd like to quickly introduce our panel: Rick Collins from Northern Bureau, Nate Weissich from Central Bureau, Robbie Bringoff from LA County, and Dave Paletta from Southern Bureau. This session is being streamed and will be recorded and placed on the Post website on the decertification page for future viewing. We will be taking questions via the chat box. We will not be answering any questions regarding any current open cases with Post or cases that are specific to you. We encourage you to contact a law enforcement consultant from your region so you can discuss so they can discuss that with you further one-on-one. We will answer as many questions via chat and live as possible within the 50-minute time frame. Dave, I'll ask you the first question. Is it true that POSAD will investigate a case even if the offending officer is retained by his organization or the officer wins their appeal at Skelly?
Thanks, Christine. And the short answer is yes. While the results of the disposition of the agency investigation are taken into consideration, each professional conduct bureau is responsible for conducting an independent assessment, and that word is important, independent assessment of an analysis of any alleged serious misconduct before any recommendations for action is taken. And so with that, agencies generally look at violations of department rules and policies, and the definition of serious misconduct may not align with the language in those policies. So Post also need to gather additional information, and that's what our job is here. To answer the question, Skelly results, arbitrator decisions, even criminal proceedings are reviewed as part of the case assessment. And so what gives us the authority under Penal Code is 13510.8 sub C sub 6, if you want to reference that further.
Okay, thank you, Dave. The next question is going to go to Rick Collins. What is the process for decertification, and what are the appeals processes for this?
So the decertification process is multifaceted. It starts with the investigation and review by the law enforcement consultant. If the LAC believes the case has the potential to move forward, then the LAC will present the case in what we call a BC panel review, which is in front of the bureau chiefs. If this is where the LAC presents the facts and evidence of the case, if the BC panel review believes the case can move forward from there, then the LAC will write what's called an investigative summary and findings. In conjunction, Legal Affairs Bureau attorney will be assigned to the case, and they will work together to refine the ISF, which will then be presented to the EXO's office for their review. After the review, the LAC will present the case in front of the EXO, along with several attorneys in the room. It is the decision of the Assistant Executive Director in consultation with the Chief Legal Affairs Bureau attorney to see if the case is going to move forward or not. If it does move forward, the subject officer is sent a determination letter informing him or her of the findings. The subject officer will have 30 days to appeal, and a public hearing by the board will be scheduled. At the hearing, the findings of the investigation will be presented, and the board will make the recommendation to the commission for revocation or suspension when appropriate. The commission shall review the recommendation by the board. If the commission supports the board's recommendation, the division will initiate proceedings for a formal hearing before an administrative law judge.
Thank you, Rick. The next question is going to be for Nate Weissich. When Post closes a submitted complaint, does the agency and/or officer get a notification of the outcome?
Yes. Post, excuse me, Post sends a written notice by U.S. mail of any closure or any proposed regulatory action to the agency and to the subject officer. The subject officer's notice will be sent to their address of record, which defaults to the agency. And that's where I'll just use the opportunity to remind everybody to that it's helpful if you've updated your address of record via the your PostPass account, just to make sure that you're getting notice as quickly as possible and it's not getting lost between your employing agency and you.
Thank you, Nate. The next question is going to go to Robbie Bringoff. Does an agency with a sworn peace officer under decertification review by agency and/or post have an obligation to notify an agency who is making an active background investigation inquiry of that person who is an applicant as a lateral peace officer?
Okay, so the question is, does an agency have to tell another agency that they've submitted somebody to us for decertification review? Short answer is no. However, you have to tell us at Post, and then we have to tell them. So through transitive property, we'll get there, and there's an avenue to get that information. But there's no mandate that the agency that's employing the individual officer, the subject officer, tells an agency that has that person in background.
Can you go through the steps maybe of what an agency has to do if they have a background with a lateral officer, what the requirements are?
Yeah, I don't know the law off the top of my head, but they do have to contact Post and inquire as to whether that person has any serious misconduct allegations filed with us. So that information will ultimately get to the hiring agency.
Okay, thank you. Next question goes to Dave Paletta. Are there any consequences for the agency if an IA is not submitted within 10 days?
So per statute, agencies are required, and it's a shall report serious misconduct allegations, complaints to Post within the 10-day period. However, with that, there's no statutory consequences for an agency not to report. In the instance Post learns of an allegation or an instance out there, we'll contact the agency. We're still educating agencies on how SB2 works and functions. And so we'll definitely get their cooperation or try to get their cooperation. Post does report back on the agencies that are reporting to us. So there is checks and balances in place. And then as LECs and Post, we have the ability to conduct independent investigations should we find something or learn of something. So.
Okay, thank you. I'm going to pose this next question for Robbie. How does decertification affect JDEPs or jail deputies who fall under 830.1C of the Penal Code?
So jail deputies are still subject, those under 830.1C are still subject to SB2. However, some of them may not have a post basic. So their proof of eligibility would be subject to revocation or decertification. So they are still subject to it. It affects them the same way that it would any other sworn peace officer.
Okay, thank you. The next question's for Rick. How does Post differentiate between sustained cases of excessive use of force for decertification?
I would say each case is examined by its own sets of facts and circumstances. A good look at the evidence coupled with the different layers of review that happens internally will determine if clear and convincing evidence exists to move the case forward for decertification.
Okay, thank you. Sorry, we're just trying to get through all the questions on the chat. Did one of you want to answer pose the question on the chat?
If a law enforcement agency does a criminal investigation of an officer in another jurisdiction, what are the SB2 reporting expectations of the investigating agency?
I think I can answer that one for you. So the criminal investigating agency, let's just assume that that's what the asker is asking about. Does the criminal investigating agency have any SB2 reporting requirements? The answer is no. It's the employing agency that has the reporting requirements and mandate. So anybody who's doing a criminal investigation of a peace officer is not obligated to report that to Post pursuant to SB2. However, the employing agency would be subject to that. The interesting instance is if that person's not currently employed by an agency, and that's something that we would have to take on a case-by-case basis.
And Robbie, I just want to add to that. So the agency that's employing the individual is still responsible for doing an internal affairs investigation and supplying the criminal documentation from the outside agency to Post. Sometimes there's a misunderstanding with that.
Okay, one question for the panel. How long does it take for Post to complete an SB2 investigation once it's begun?
Let's try.
Go ahead, Dave.
It's difficult. Each case is unique to itself. And so some cases are very simple to look through and we make a quick assessment, and other cases are very complex and they have multiple pages of documents that we have to review in order to make an assessment. And as in the last question, some cases are pending a criminal complaint. And so before we take an action, we want to have all that information to make a valid assessment on which way our investigation needs to go. Some cases we can turn over very quickly in a couple of months, and other ones that have the pending arbitrations, potential skelly or waiting for an internal affairs investigation take several months beyond that to complete. So not to avoid the question, there's just a lot of different layers in there that impact how long it takes a law enforcement consultant to complete it.
Yeah, and then to Dave's point, it can take, we have 3 years from the receipt of an IA investigation, so that's an important benchmark as well. So once we receive a complete IA investigation, we have 3 years to investigate that allegation of serious misconduct. If we don't receive an IA investigation, there's no real timeline that begins. So that's an important consideration.
Okay, another question that's come in. Post wants to interview several employees, both sworn and civilian. Does POBAR apply? And second question is, can a representative attend the interviews? Go ahead, Nate.
Post is not the employing agency. Therefore, the peace officer Bill of Rights doesn't apply. However, Post will provide notice to the subject officer and provide them an opportunity to have a representative with them. As long as that, I should mention that representative isn't a party or witness to the actual investigation.
How does a subject officer know if they have a SB2 complaint pending with Post?
Yeah.
Go ahead, Dave.
So if they're still employed with the agency, they can contact their personnel internal affairs division. If they're not employed or if separated, when you look at Post's website, the professional conduct bureaus are broken up into our areas. And on Post's website, we have phone numbers and emails. You could easily, where you were last employed and where the offense potentially occurred, you could just reach out to that bureau and ask the question, and we'll tell you if we have something and the status of that investigation.
I would also add that making an inquiry through GovQA, a public records inquiry, is an avenue to see what allegations Post has on file for you, and you're entitled to that information.
Another strong indicating factor is whether you've received a notice of investigation letter. So that's another fine way to know if you have an investigation pending. So those usually come to the address of record, and like Nate said earlier, update your address of record. That makes it a lot easier for us to get you that information.
And there's some question on that when we send the notice of investigations. People that receive them don't know what they're about. They'll read the language, but I think there's some hesitancy to call the law enforcement consultant to figure out really what it means and what their options are. And so we would encourage that if you receive one of those letters, don't be afraid to call, and we'll explain, even to the point where we're looking at potentially where the case is going to go, and we could tell you what the potential options are and kind of take the mystery out of this process.
a question that came through the chat. Does CDCR report to post with any type of decertification investigations?
I'll take that one, Christine, and the
Right, right.
answer is no, they do not.
Another question on the chat is, how do agencies determine if the criminal act by an officer meets the acts that violate the law and are sufficiently egregious? Go ahead, Rick.
I'll take that one. That's a good question. Egregious is ambiguous, and a search on Google came back with a couple of different definitions that I'll read. And it says, egregious is defined as outstandingly bad or shocking, extremely bad in a way that is noticeable. There's also some language in the statute that suggests it depends on the crime that was committed by the officer, and I'll read that as well. Sufficiently egregious or repeated as to be inconsistent with a peace officer's obligation to uphold the law or respect the rights of members of the public as determined by the commission. So that might suggest that maybe if you have 2 DUIs within 4 days, that would be repeated. Possession of child pornography or an arrest for domestic violence might be egregious, but it's going to be dependent on the facts and circumstances of that individual case and determined by the commission.
Okay, thank you. Another question that's come in, if an officer declines an interview with post, does an officer get charged with failure to cooperate?
They certainly could. That's one avenue in which you could fail to cooperate with a post investigation. But they also have the right to not provide a statement. So you have to kind of weigh the circumstances. But yes, if an officer is choosing not to cooperate with the post investigation, that is serious misconduct.
And I would just add, just like an internal affairs investigation, if we don't have that statement, then the officer doesn't get to tell his side of the story, which may or may not be important. And so we rely on just the documentations in which we received, which sometimes having the officer's input could steer it one way or potentially a different way.
Okay, this is a question through the chat. It's a little extensive, so bear with me. Are agencies supposed to submit incidents to post every time someone utters words of police misconduct? i.e., driver tells officer who only stopped me because of a certain race, or arrestee claims officers broke their arm by placing them in handcuffs, but they suffered no injury. Is their baseless claim supposed to be submitted to post?
Yes, it is. Even if the allegation is frivolous at face value, that allegation should be submitted to post. The agency has to determine whether the allegation could affect the officer's certification status. And that's kind of the judging factor. So yes, some agencies have reported everything and they classify every instance of somebody uttering an allegation of potential bias as a reason to report to post. And we do agree with that. That is correct. A frivolous allegation needs to be submitted to us. But it's not any time, just to be clear, it's not time anybody utters something about serious misconduct. It's whether the agency identifies that potential allegation, whether frivolous at the set off or not, could affect somebody's certification. So the short answer is yes.
Thank you. Is it correct that any sexual act on duty is considered a sexual assault and therefore an SB2 violation, regardless if it was consensual or not? Nate?
By definition, that's 832.7 and plus the commission regulation 1205.4. Anybody want to help me out?
There's been some discussion at the commission about this point. And and I don't remember how many commission meetings back there was, but one could look back and see the discussion and listen to the discussion about this issue. We have not had cases that necessarily set precedent in this area yet. So that is a consideration that we as a profession and the regulatory body need to consider. As Nate said, yeah, that is by definition sexual assault under that code and that statute. However, we take each instance into consideration. But at this point, those should be reported to Post, and those allegations should be reported to Post, and we'll take our investigation and look at everything on a case-by-case basis. No, it doesn't completely clear up the question, but Nate's right. Yeah, it is an allegation. That is the definition. And so as we push these cases forward and we investigate these cases, we will be able to set precedent and make better determination on what kind of cases the commission wants to see moving forward. But at this point in time, yes, it is. And yes, it needs to be reported.
Thank you. Okay, can someone on the panel expand a little bit more on correctional officers being subject to SB2? We were under the impression they were not subject to SB2, but sounds like they are. So I think if somebody can just differentiate CDCR versus jail deputies.
Yeah, so that was my question originally. The question was about 830.1 sub C and whether jail deputies under that subsection are subject to SB2, and they are. CDCR is sworn under a different section. I don't know off the top of my head what it is, but I do know that jail deputies, and one can look up 830.1C, and it has a list of counties, and there's only a few that aren't part of that. But jail deputies in those counties that are considered deputy sheriffs and not correctional officers are subject to SB2. And that's how one would tell the difference between a CDCR officer and a jail deputy.
Thank you. Does Post currently have sufficient resources, personnel to address the high volume SB2 reports submitted? Go ahead,
Post
Dave.
is always hiring. And there's a volume of cases that need to be looked at. And so I could speak for probably all of us here that our queues aren't short of things to look at, and we get them new cases every day. And so are we short? Well, I don't necessarily know that we're at staffing levels that we want to be at this point. And so, yes, if you look at Post website, it shows you all the jobs that are available at all positions, not just law enforcement consultants. And so I would just say we could always use more help, especially on the Professional Conduct Bureau.
Okay, does dishonesty as it applies to serious misconduct only apply to dishonesty related to the investigation of a crime or reporting another officer? Or is the meaning more broad?
I can attempt to answer that, but I probably would tap counsel for the nuances on this one. But if one looks at the statute, it says dishonesty relating to the reporting, investigation, or prosecution of a crime, or relating to the reporting of or investigation of misconduct by a peace officer or custodial officer, including but not limited to false statements, intentionally filing false reports, tampering with, falsifying, destroying, or concealing evidence, perjury, and tampering with data recorded by a body-worn camera or other recording device for purposes of concealing misconduct. So the way that we're interpreting it right now, and most of the dishonesty cases that we're bringing forward is the cases of dishonesty in which a subject officer has been dishonest with IA investigators or with us during an investigation. And I could tap counsel for nuance to that.
Yeah, hi, Chris Becker. I'm Assistant Chief Counsel with Post here. I think that Mr. Bringolf's explanation was right. I think that if you look at the statute is 13510.8, subsection B, subsection 1. And it talks about relating to the reporting, investigation, or prosecution of a crime. That seems to be the first prong. The second prong would be the reporting, investigation of misconduct by a peace officer. So I would just urge people in the audience to take a look at the statutory definition. So it seems to be the two aspects of that. So if you're dishonest relating to the reporting, investigation, or prosecution of a crime, that's one aspect. The other aspect is if you're dishonest relating to the reporting of the investigation of misconduct. That seems to be the other aspect. And then there's some qualifiers that help clarify. So including but not limited to false statements, intentionally filing false police reports, tampering with, falsifying, destroying, or concealing evidence, perjury, tampering with data recordings by a body-worn camera or other recording devices for purposes of concealing misconduct.
Thanks, Mr. Becker. And I think that just to kind of nod to the through line again is if you're not sure, report it to us and let us make that determination. We have plenty of cases that of dishonesty that are reported to us that we need to review and take a look at. And then we make a determination as to whether we're going to move forward on those after some review by our staff. So if it looks like dishonesty to you and to your agency, it potentially meets the dishonesty definition for us. And so we could take action on that. So please submit it to us and then we'll make a judgment call when we see it.
Can you underscore the 10-day reporting requirement, even in events where claims that may meet criteria but are frivolous?
Yeah, you need to report it within 10 days. So I'm not sure how else to underscore it other than you have 10 days from the time that you are notified of the potential serious misconduct to report it to us. If there's an investigation that's pending or an internal investigation or for some reason you don't want the subject officer to know that there's an investigation pending, we have avenues to go about reporting that so that we don't jeopardize any administrative investigation or criminal investigation. But the mandate is that it's reported to post within 10 days of discovery by the agency.
And just to add to that, that entry could be very simple into what the system that we get it is Mark 43 in that we received this allegation and we're looking further into it. So it doesn't have to be a completed investigation at that point. But to Robbie's point, it does have to be reported to us within that 10-day period.
If I can add just a little bit too. So the relevant penal code section is 13.510.9. And it states that beginning January 1st, 2023, any agency employing peace officers shall report to the commission within 10 days in a form specified by the commission any of the following events, and the relevant subsection is subsection 2. Any complaint, charge, or allegation of conduct against a peace officer employed by that agency that could render a peace officer subject to suspension or revocation of certification by the commission under subsection 13.510.8, and that sets forth the 9 areas of serious misconduct.
Can one of the panel members explain to the audience if an officer receives a notice of intent to revoke letter? What are the expectations and can you explain the process from that forward on?
So notice of intent to revoke, correct me if I'm wrong, Chris, but this is after we've done our ISF and we intend to move this forward. Is that the letter? Okay, so if an officer receives that letter, essentially it means we're moving forward and we're going to take this case in front of the board to make a determination as to whether it should go to the commission or not. So what you can anticipate is that investigation is going to be posted publicly. You're going to be able to review the evidence that we used in that case to come to our finding, and that you would have this board hearing. Next would come the commission hearing, and then potentially the administrative law hearing. I'm not sure if that's what is being asked specifically, or if that's specifically what you're asking, Chris, but that's my understanding of what one can anticipate. That notice or that letter typically has the investigating consultant's name and phone number on it, or the bureau chief that's responsible for the bureau in which the subject officer is employed, that jurisdictionally employed. So you could always reach out to us, to that number at the end and give us a buzz and ask the questions. It's a pretty open process, and it's pretty, we can discuss that to an extent at that point because we've completed our investigation. Yeah, and then your counsel can, if you so choose to have counsel represent you, your counsel can reach out and get copies of that evidence. So that is what I would expect. I don't know if there's something more specific that's being asked, but generally that's probably what you can look forward to.
And in that letter, it's also an opportunity for the officer, if they want to voluntarily surrender and not go through that process that Robbie articulated, it gives them the opportunity to say, I don't want to go through this, or I don't want a panel here, or this is embarrassing, so I want to stop it at this point, and basically sign a waiver that says they're done. If they do that, their license is revoked. But once again, that's all explained in this process.
Can I add just one more quick thing? So when the notice of intent to revoke is sent out to the subject officer, they're also given an opportunity to reply with a request for review. So that's what triggers the board hearing. If there's no response, then it would be a default as to revocation or suspension. So when they get the notice of intent to revoke, it's important to take a look at the entire package, pay attention, making sure that you see that there is a request for review, and that would be what triggers the next step as far as the board and then the commission, et cetera.
Yeah, that's a really helpful point. Thanks, Chris.
Can I take the opportunity to, even though I may be beating a dead horse, but the address of record, this is another concern we have with officers, peace officers who decide not to update their address of record with a personal mailing address. At the point in the process we're talking about, officers are frequently separated from their agencies and may not even have a good working relationship with the agency. Absent an address of record, these notices are being sent to the agency or the last known address we have for you. And it's incumbent on you to respond to post within 30 days. It's only incumbent on post to send that notice to your address of record. So another plug to log on to PostPass and update your address of record.
Can I just add one quick thing just to kind of allay some fears? The address of record is not public information. That is internal for post use only. So if you add an address of record for us, that is just so we have a way of getting in touch with you. That is not public information.
And I'm assuming that that's not subject to Public Record Act request as well, correct?
Correct.
Okay, so that's helpful to know for everybody out there.
Okay, next question is, how long does Post retain records for officers who have been the subject of an SB2 investigation?
Take it on. Post retains records for 30 years, unless that officer passes away, in which case they can make the determination to destroy the record sooner.
Okay. Next question is what is the burden of proof for Post to decertify? Go ahead, Rick.
The burden of proof is clear and convincing. The clear and convincing evidence standard is what we are bound to look at a case for.
And can you explain the differences between our burden of proof versus an agency's internal affairs investigation?
An agency's burden is preponderance of evidence, and our burden is clear and convincing, which is a higher threshold. It is not that of beyond a reasonable doubt. It is a little bit less than that, but it is more than preponderance of evidence.
Yeah, one way, just to kind of tag along with Rick here, one way that we look at it is that the evidence must be substantially more likely to be true than not true. And yeah, I think that's the way that we look at it. It requires a firm belief that the facts happened that we're looking at. So.
Okay, next question is, at what point does an officer's name go on the Post certification action list on the website?
I can try and answer that question. I may have to ask. I might have to phone a friend. But the way that I understand is once either a default judgment has happened, or they turn in their certificate, then their name would go on that list. Also, if we have a immediate temporary suspension, the officer's name would go on that list. With a show of a thumbs up, how am I doing on that answer?
I'll add a
Potentially.
another category. Post has deemed the officer ineligible or has revoked a license pursuant to Government Code 1029.
Okay, yeah, 1029, that's a good one too.
And just to address questions that some of our representatives get when they speak to rank and file officers in the field, there's this myth that a name goes up simply when an allegation is reported, and that's not true. There has to be a regulatory action taken by post.
Sorry, I'm not on. Okay, if I can just piggyback on that. So what Nate said was clear. So if your agency submits a report of serious misconduct, your name will not be listed. Post only lists the names of officers where Post has taken regulatory action against a licensee. This includes cases where, one, Post has made a finding of serious misconduct and has issued the officer a notice of intent to revoke. Two, Post has deemed the officer ineligible or has revoked a license pursuant to Government Code 1029. And Government Code 1029 is the section where if you have a disqualifying conviction, be it a felony or in some instances based off of the year that your conviction happened, some misdemeanors, you would be ineligible or we could revoke your certification. And then the third is if there's an immediate temporary suspension.
Does anyone on the panel want to explain the notes of an investigation letter that are sent out to officers?
A notice of investigation is just that. It's a notice that we've received an allegation forwarded to us by an agency that we're looking into, and it's our attempt to be transparent with the officer and reach out and open a line of communication. It'll have the investigating law enforcement consultant's name and contact information. We're happy to answer questions about the process, discuss your individual case to the extent we can. And again, we want to open that line of communication because we may very well want to re-interview you. IA investigators are very good at what they do, but they're investigating violations of agency policy, which there's a lot of overlap with serious misconduct, but it's not always the same thing. And so there's oftentimes a lot more clarification that we need. We also are interested in hearing mitigating information and hearing your side of the story. So I don't think there's any advantage to shying away from contact with post or ignoring a notice.
I just piggyback from my personal experience when people contact me on investigations that I'm looking at. Sometimes they'll enlighten me on information that I didn't know existed, and so that's also helpful that for our investigation purposes to be able to close those loops, and we can go back to the agency and ask for additional information, or in some cases, the officer supplied it to me directly. So to Nate's point, there's no disadvantage to having that conversation, no matter what the allegation is.
Thank you. This question will be for Chris Becker. Do post findings, reports, or investigations or allegations ever become public documents?
Forgetting to turn this on. So I'll answer that twofold. So first and foremost, when an agency submits personnel records or investigative records into post, if somebody were to submit a PRA request asking for particular documents, and that's an active investigation, if you look at the CPRA under the government code, if you look at those regulations, it's in the 7,000 series. The way that post handles those requests is that we do not provide personnel or investigative documents to the individual. What we're instead required to do is forward those requests on to the originating agency who had conducted the investigation. And then we will let the requester know what we had done with the request that we had forwarded on to the originating agency. So first and foremost, we do not provide those documents under the PRA. Second, if you look at the statutory scheme, the way the SB2 is set forth, the only way that documents part of an investigation become public is when they're presented to the board. So everything that we feel supports the investigative summary and findings would be attached as an exhibit to the investigative summary and findings. That would then be submitted to the board. It would be attached as an agenda item that would go before the board, and then that information would be public. So hopefully that allays some concerns about public documents.
Can any of the panel members talk about the statement of finding that's posted on the website and what that means?
I can if if you would mind me answering. So the statement of findings is something that the Post has been providing on our website. The statement of findings is going to be instances where Post has taken in a complaint about serious misconduct about a particular officer. We've investigated it. We found that in our view, that clear and convincing evidence exists to take action against that individual certification. In the statement of findings, actual scenarios, specifically, those are instances where the officers have not responded, and so it's been a default revocation. And so under our obligation to the public to talk about regulatory actions that we've taken, we've produced these statements of findings. The statement of findings will talk about the allegations that were presented to Post, that Post did its own internal investigation, found that clear and convincing evidence existed to support that serious misconduct had taken place. We list the relevant penal code section talking about what serious misconduct aspect was violated, and then list that, hey, we sent out the investigative summary of findings on such and such date. The officer had time to respond, no response was taken, and so a default revocation action was taken. And so that's what the statements of findings are.
Thank you. We're getting a lot of questions in the chat about frivolous complaints and how Post deals with frivolous complaints or complaints or allegations that end up from the agency being exonerated or unfounded. Can one of the members maybe explain how we prioritize our cases and how we close them out?
So the SB2 casts a wide net of what's reportable, and that does include frivolous cases. It does include unfounded or exonerated cases. Post will review all of those cases independently and make its own findings that there's whether or not there's clear and convincing evidence that the allegation is true. So in the vast majority of the cases that are described in the question, they would be a quick review or a thorough review, and then a closure would be, and the officer would receive a closure statement from Post.
Just to add on to that, for years, agencies have been accused of covering for their own officers. And so SB2 is an attempt to make complaint processes a little bit more transparent and have additional set of eyes look at cases to see if we come up with a different finding. It doesn't mean we're going to, but we will, like Nate said, look at everything and all the documents just to make sure that we agree with it. And if we don't, we'll have a conversation with the agency to potentially take another path.
Okay, thank you. This might be a little bit of a repeat question, but I think it's important, again, to answer. What kind of communication and notifications can the subject officer and the agency expect from Posts related to serious misconduct investigations?
Well, during an investigation, a Post investigator might decide to interview you. So we would contact you and give you notice of that interview. Clearly, as Nate discussed earlier, POBAR doesn't apply to post investigations of serious misconduct. So you would have an opportunity to have a rep present. But I think that's the main thing, is understanding that we're going to reach out. We send closure letters, we send notices of regulatory actions, notices of intent to revoke, immediate temporary suspensions. If you receive a letter where we're seeking to take regulatory action against your license, you should review that information. And if you want to challenge our decision, you can file a timely appeal with us. And keep in mind that timeframes for the appeal can be relatively short. I think the shortest amount of time is 30 days. So we'll sometimes send you a notice of investigation letter, which notifies you you're subject to a serious misconduct investigation and provides information about the decert process and your options. And if we don't hear back from you after sending out the notice of investigation, we might decide to follow up with an email or a phone call. I've reached out via phone call several times. There's a lot of information available in open source on the internet where you can just find your cell phone number and give you a buzz, and we've done that. So we're happy to answer any questions that you might have about that if you receive some sort of communication with us. Most of us are aware why we're trying to get a hold of you. So reach out to the consultant whose name is at the bottom of your letter, or to the bureau whose chief's name is at the bottom of that letter, and they can direct you to the appropriate investigator or consultant. So.
Add on, with regard to communication with the agency, our goal is to be both independent and transparent and open, if that makes sense. So we're conducting an independent investigation, but there's going to be ongoing communication with IA or the Mark 43 reporters that are designated by that agency as we request more documents, look for other evidence. And we also try to never surprise an agency if an immediate temporary suspension is in the works. We don't want the first indication of that to be a letter in the mail to your agency head. Hopefully you would know the agency would know that was coming, because we would be asking for documentation that we need to complete that process.
Okay, thank you. If an SB2 violation is sent to post and the officer voluntarily relinquishes their certification, does the post investigation cease, effectively blocking the investigation from going public?
I'll attempt to answer that question, and the short answer is yes. If the subject officer voluntarily surrenders their certification, I think the process transfers over to our certification bureau and they handle it from there.
If I can just add to that, I think that probably the best way to provide information to our audience in this instance is that the Post website has a copy of the voluntary surrender form. It's the Post 2-358 form on the website, and it sets forth the all of the information that you're probably going to want to know about. I'll just read a couple here, just for people to have it in front of them. Post will conduct no further adjudicative proceedings regarding my peace officer certification as provided in Penal Code Section 13510.85A. I am waiving any right I may have to a hearing before the Peace Officer Standards Accountability Advisory Board and Post Commission as provided by Penal Code Section 13510.85. And there's 7 in here, but I just wanted to kind of give you just a flavor of the first couple of 2, but it's probably best that if that's something that somebody's considering or somebody's interested in knowing more about, that take a look at the form on the Post website. Also, one thing to add is that Post does list voluntary surrenders on the website.
Okay, we're just about at the top of the hour. I'd like to thank our panel members and those that attended online. Again, this is a recorded, we'll have the recorded version up on the website within the next few days. And thank you for attending.